And so my name is Furon Chen, and my student number is SK024110. And I'm just going to do a brief introduction of ASIC versus Casamatis case. So in 1994, Mr. and Mrs. Casamatis built the store company in Townsville, and they both are the directors of the store company, and they introducing the store model advice to the clients. So store model is to encouraging clients to borrow against their home and then invest to the index fund. And then after 2008, Mr. and Mrs. Dodson, who was around 55 years old, ended up with a loan of $287,000 and a credit line of $32,000, and as well as lost all their investment and ended up with not be able to retire. And on the 21st of December 2010, ASIC made the case against Mr. and Mrs. Casamatis in the court in Brisbane, and they have argued that Mr. and Mrs. Casamatis provided a commoditized financial advice, which is one size fits all, and without consideration of the vulnerability of the client who was not able to make this investment and ended up with not be able to retire. The ASIC has argued that they have breached the Corporation Act 180-1 as well as Corporation Act 945A. Under the 180-1, the director is supposed to give a degree of care, and in this case, Casamatis failed to provide an honest and fair advice which is tailored to the clients. And under the section 945A, Mr. and Mrs. Casamatis are supposed to give use the information and then provide the personal, considering their personal circumstances, and give a certain investigation and provide a reasonable advice. In this case, Casamatis has failed to provide an appropriate advice to the client, like Mr. and Mrs. Dodson. And then for the next part, I'm just going to invite my team member, Peace.
Thank you, Faye. My name is Chidima Pesigwe. My student number is UEM 2023. And now I'll be talking about the issues relating to the application of the section 180-1, which is care and diligence. And in this case, we have three major issues relating to this application, which I am about to discuss with you. Firstly, Justice Ed Lehman judgment considers such issues as to whether an actual breach by the company was needed for the directors to violate section 180-1. And again, ASIC on their own argued that based on the fact that Stump violated Corporation Act, the directors also did. And the judge also seriously doubted if this is the actual breach of 180-1 by the directors. So when we talk about the issues relating to application, we are saying that the actual decision has not really taken place, but they are still bringing the argument, what they think happened, what they think must have gone wrong. So they're just bringing their opinions together. And now we're going to talk about the second issue relating to this application. The judge raised an issue if specific duties under 180-1 are owned exclusively by the firm. ASIC on their own also recommend that separate conduct from the company's interest so that the directors owes the public a duty. And again, directors also on their own try to defend that duties are owned exclusively by the firm under 180-1. Though Ed Lehman admitted that and noted that the company's interest must not be constructively, limited to only shareholders. Okay, and the third issue we'll be talking about is the judgment sought to determine if the directors are answerable to the breach, especially in this case they are both the directors and the sole shareholders. And also directors on their own try to say that since they both are the shareholder and the and the director of the company, that they cannot violate the Corporation Act. Finally, the judge argued that the director should act with diligence and care despite intentionally contravening the corporate law, corporate act. Thank you so much. Now I'm going to invite Rukuma to come and talk about the cost decision and reasons why the corporation made the decision they made.
Thank you so much, Peace. My name is Rukma Iftikhar and my student ID is BSS20419. Now I'm going to discuss about the court decision in this case. Justice Adleman ruled that Mr. and Mrs. Casimir's violated section 180-1 as well as section 9458-1B and section 9458-1C of the Corporation Act. As the respondent of the Storm Company, both the directors has violated section 180-1 because they providing financial services based on the Storm model to the suspectable investor identified by ASIC, as well as both the directors infringed their duties of diligence and care. The second one is the breach of section 9458-1C because Storm did not conduct a thorough analysis of the advice model followed by the company. And the third breach of section 9458-1B took place due to the provision of inadequate advice. At the end, the court also established that there was no criminal breach of section 1041E or section 9458. Now I am going to discuss about the remedies and the cost regarding to the breach of the Corporation Act. On 7th September 2016, Justice Adleman ordered that the proceeding be set down for hearing on remedies and cost on 1st February 2017. Then, on 22nd March 2018, Dorset Jail handed down judgment on penalty imposing civil penalties of $7,01,000 on each of the directors. But the important thing over here is this, that the penalties amount paid will not form part of investor compensation, as the Corporation Act 2001 requires that they must be paid to the Commonwealth government. And in the judgment, it is also decided that both the director disqualifying from managing corporation for 7 years. Thank you so much. Now I am going to invite Rajvinder for discussing the further part of this case.
Thank you, Rukma. Now I am going to explain about the impacts of the decision on the operations of the companies in Australia in relation to Corporation Law Act 180-1. This case is very famous about director responsibility towards company and their obligation to clients, and it have a great impact on the decision to the operations of the companies in Australia. After the court decision that Casimir violated corporation law, other companies in Australia should strictly follow these requirements. As a director of a company, they must perform duty of care. Some of the key issues identified through these cases are: firstly, companies in Australia should be well aware that firm hold the duty of the company, but as a director, they need to consider the interest of the clients as well. Secondly, shareholder will not be liable for the Corporation Law Section 180-1 because it is director who are able to rectify the act. Directors in Australian companies should always act under duty of care and not push the responsibility to shareholder. Thirdly, act of not fulfilling an obligation, promise and agreement can be enough to break corporation law, section 180-1. Companies in Australia should be well aware for these differences and be mindful to fulfill of the contravention and make sure to fulfill the duty and obligation as a director and perform a duty of care. That's enough for my part. Now Priya will explain the further part.
Thank you, Rajvinder. So as my friend said, this is one of the important and very famous case. So today I'll be covering these important points in my presentation. So the first point will be the crucial reminder to administrator, the result in the proceeding against administrator, the proof of the establishment, lessons for directors from court, and the corporate contradictions. So this case is a crucial reminder to administrations of their obligation to superintend the conduct of the corporate in lightweight of the risk-benefit check, and the launch of the top of serious contraventions may perhaps result in proceeding against the administrators for a breach of the duty of care and diligence. Moreover, the proof established that in their day-to-day management of the firm, Mr. and Mrs. Casimatis were each integrally concerned in virtually established of the Storm's business, and furthermore, they they exerted an extraordinary degree of management over storm. And next point will be lessons for director from court. So the first lesson was under section 180-1 of the Corporation Act law. Administrators have to exercise their powers and discharge their diligence and obligations with the degree of care and diligence that a sensible person in their role would exercise. The decision in Casimatis is an essential suggestion to directors of their commitment to director and the lead of the organization as well. So to conclude the part, the idea that directors can be at risk for corporate contradiction is not new. In any case, the choice in Casimatis has given some further knowledge into the parameters of their obligation, and that was all from us. Thank you so much.